Good morning, my dear friends. Okay, my name is Professor Harsh Kachalia, and I am here for your CA final law. Okay, there are a few things before we start the subject. I want you to be very clear with some things. So have a look at the chart that is in front of you. At first, CA final law is divided in two parts. It is divided in two parts. One is your corporate law, another is your allied laws. The corporate laws consists of 70 marks and your allied laws consists of 30 marks, as you must be aware. Now, the important thing here is the 70 marks is what you have to attempt out of the 80 marks paper, and the 30 marks you are expected to attempt out of your 40 marks paper, meaning your paper comprises of total of 120 marks, of which you are expected to write for 100 marks. So when you study your CA final law, all you need to do is some smart work more than some hard work. Why? Because there are flat 20 marks which comes from particular chapters, a few of corporate and few of allied, which even if you don't study for your exams, I guarantee you are able to attempt a paper of full 100 marks and score well. Okay. Now, another thing, talking about your CA final law, corporate law, I further divide the corporate law in the further two parts. One is your directors and one is your other corporate laws. Now, the directors, what I am talking about is, it comprises of nearly 30 marks of your portion. 30 marks of your corporate laws, meaning out of the 70 marks, 30 marks is for directors and rest is for 40 marks. If you have ever seen the index, it comprises of totally nearly 26-27 chapters, out of which 10 chapters are for allied laws and the rest 17 odd are for corporate laws. Out of the 17 odd, please listen to me very carefully. Out of the 17 odd chapters, you have 3 chapters which come for 30 marks and others totally come for 40 marks. Now you can imagine the importance of directors. Okay, this directors is given into 3 parts in your book, in your study material. One is your appointment of the directors, one is the board meeting, and the third is managerial remuneration. I treat them as one chapter because it comprises of section 149 of the Companies Act 2013 up to section 205 of the Companies Act 2013. That is your directors for you. Okay, now consider talking about directors. Be very careful when I'm saying this. Talking about directors chapter, today I'll explain a few concepts about the directors chapter. Chapters to you, and I want you to understand them very clearly, mind you, because these concepts are at every point they are logical. Okay, nothing in law goes without logic. If someone tells you this is the provision because it is the provision and you have to do it that way, that is not how you study law. Everything has a logic, and I'll make an attempt to explain every logic to you so that if the concepts are clear, it is very easy to clear the papers, very easy to write your exams, right? So talking about directors, starting with directors, one fine day I had a thought, let's become a director of a company. And then I thought, if I want to become a director of the company, am I eligible to become a director of a company? My question is, can I become a director of a company? I don't doubt my capabilities. Yes, I can. Can you become the director of any company? Don't doubt your capabilities. Even you can become a director of any company. If I can become, you can definitely become, right? Okay, so the question is how? How, as in, I have a passport as proof, I have Aadhaar card, I have a PAN card. So aren't these enough proofs which can help me prove my identity? They may be enough. We are not denying the fact. They may be enough, but as a matter of fact, you also need to remember that even if they are enough, guys, you need something else to become a director. You all are the members of a very reputed institute which is known as the Institute of Chartered Accountants of India. And being the members, you are yet students though, you have been given a registration number, right? You can talk to any of your friends and ask them whether any of you have a common WRO, CRO, whatever number that you are using. Any of you have a common registration number? It is not possible. It is not possible for anyone to have a common registration number. Means every person has a separate identity, and that identity can be used, that identity can be known with the help of your WRO. Institute can come to know how many attempts you have taken to clear your CA exams only by a click on your WRO number, right? So now the point is, because the institute can know it so easily, it has given you the WRO number, a separate identity. If you want to become a director of any company, you need a number like that. You need a number like that, which is known as a DIN. DIN as in the director's identification number. The DIN is nothing but a director's identification number. Talking about the DIN, now very clearly, oh, I need a DIN to become a director. Fine, I'll get it. I'll take the DIN, but I need to know, where do I get a DIN? First, I need to know, where do I get a DIN? Do I get it at any railway stations? Do I get it at any stalls, any shops, any malls? Where do they sell the DIN? Guys, it is not sold. It is not sold. You have to obtain a DIN. How? Mind you, listen to the procedure. Section 152 is a wider section. There are nearly 6 to 7 subsections in that, but there is one point which is very important right now, so I am just grabbing that one point out of 152, which says if you want to become a director, you must have a DIN. I said okay, if you want to become a director, you must have a DIN. Then my question was how? It was simple. 152 told you to have a DIN. Apply in 153. If you apply in 153, you will be allotted in 154. Okay, the question is, whom do I apply? You have to apply for a DIN to CG. CG is your central government. Okay, you have to apply for your DIN to CG, that is the central government. The central government will allot you the DIN in 154 within a period of 1 month from the date of your application. Within a period of 1 month from the date of your application, CG will allot you, and if it fails to allot you the DIN within a period of 1 month, it will give you the reasons why the DIN has not been allotted to you. If your application was not in the mode and format and along with the prescribed fees as may be required, in that case you will be given a time of 15 days to rectify. Clear? Okay, I applied as per 153. I was allotted as per 154, but there was a mess. What mess? Just when I was supposed to be allotted the DIN, by mistake, I was allotted 2 DINs. I was allotted 2 DINs. Now, is it valid if you keep 2 DIN? Does any one of you have 2 PAN cards, 2 different PAN numbers? It is not PAN number, it is PAN, permanent account number. There is no concept of permanent account number. Right? It is a PAN. Does any one of you have 2 PAN? No. Means it is not good, it is not legible, it is not proper to keep 2 DIN. Okay, so if I am not supposed to keep 2 DIN, if I have got, what do I do? Listen very carefully. If you have got 2 DINs, then it is your responsibility to surrender 1 DIN. Mind you, the language is very important in law. There is a prohibition. 155 says there is a prohibition on obtaining and possessing more than 1 DIN. Meaning they have allotted you more than 1 DIN, it is not their problem. That may be a technical problem, but there is a prohibition on obtaining. You are not supposed to obtain, and if you have obtained, you are not supposed to possess more than 1 DIN. There is a prohibition on obtaining and possessing more than 1 DIN. That is the concept. Okay, but why? So what is the big problem? If I hold 2 DINs, I mean, how does it matter? It matters. I will give you an example. Assume you've got 2 registration numbers from the institute. One registration number you use to give attempts, try your CA final exams. You give around 10-12 CA final exams, get thorough with all the concepts and subjects and everything, and then you use the another DIN that you have, the another registration number that you have, and you clear your CA final exams in your 15th 16th attempt probably with a rank, and when asked in an interview, which attempt did you clear, all you have to say is I cleared my exams in the first attempt. If you want, I have my WRO number, you can go and inquire, and on inquiry they will only be seeing that yes, you have cleared your exams in the first attempt. Doesn't it give a wrong view? Okay, similar things can happen with the company. When I go in any company to be appointed as the director of the company, I may be asked, sir, please may we have your DIN? If provided I give them when I give them my DIN, they might conduct an inquiry with the help of this DIN, recover all the information that they can and verify what companies was I a director, which other companies, which are the other companies where I was a director, and if I have been a director, in 20 odd companies, and out of the 20 odd companies, 15 companies have closed down. Why wound up? Why? Because of my problem. Because I was the director who was held responsible, but I have not disclosed any of it, because when asked for a DIN, I gave them the second DIN. I gave them the another DIN that I held in my hands. Meaning what I did was gave a fraudulent view to my own character, but nobody knows. Why? Because nothing was disclosed. Correct? So that is why it is said there is a prohibition on obtaining and possessing more than one DIN. They gave you more than one DIN is not their problem. It is your problem because you have obtained and possessed. Law is all about interpretation. It is the game of words. Do not mess with them. Then we go to your next section, that is 156. 156 talks about, dude, if you've got a DIN, okay, if you've obtained a DIN, one DIN, what will you do? Will you frame it? Will you frame it on the walls? No. What purpose was which you had taken the DIN? So that the companies can conduct inquiries about you and know who are you and what kind of a person are you, with companies are you a director in. Exactly my point. Section 156 says, as a person who has obtained a DIN, submit your DIN to the company wherein you want to become a director. Submit your DIN to the company wherein you want to become a director, and you will be given a period of 1 month. You will be given a period of 1 month from the date wherein you have allotted the DIN to submit the DIN to the companies where you want to become a director. But another question comes, what will the company do of your DIN? It has no access. It has no access to inquire anything about you with just by taking your DIN. So what will the company do? The company will further forward the DIN. The company will further forward the DIN to ROC. It will forward it to ROC and then conduct whatever inquiry it wants. The company will be given a period of 15 days to intimate the DIN to ROC. Now comes the question. Now comes the logic. I was given a period of 1 month to intimate to the company. The company was given a period of 15 days to intimate to the ROC. This is where, my friends, this is where you are actually studying law. Why was I given 1 month and ROC was given 15 days? Look, all these concepts, section 153, application, 154, allotment, 5, prohibition, 6, intimate to the company, 7, intimate to the ROC, 8, 9, I'll be telling you about furnishing and penalties, leave it. But all these concepts are given in your books. Then why are you listening to this video? Why do you attend my lectures? The only reason is you need to know the logic behind everything, right? Okay, so why 1 month to me and 15 days to the company? Isn't it wrong? No, it is not wrong. Everything has a logic. Listen to me carefully. 1 month to me because first thing, I have got 20 companies to be intimated. Maximum 20 companies I can become a director in. There is another section for it. We'll come to that section. There are maximum 20 companies which needs to be intimated. Now I have to intimate 20 companies. Should I take more time or no? First thing. Okay. So coming to the company's logic. What is this act that you are studying? What is this act that you are studying? This is the Companies Act 2013. Being the Companies Act 2013, why do you think the provisions of the Companies Act 2013 shall be more stringent on me or the company? Shall be more stringent on any individual or the company? Whom shall it aim to keep on the toes? Me, an individual, or the company? A company is required to intimate only one DIN to ROC, whereas I have to intimate my DIN to 20 companies. Getting it? That is why I have been given more days of around 1 month. Companies have been given a period of 15 days to intimate, and then 57. After 57, we go to 58. 58 says a director must furnish the DIN wherever he signs in the capacity of director. A director must furnish his DIN wherever he signs in the capacity of director. Let's take an example. For example, let's say I decided to buy an iPhone for my child. I decided to buy an iPhone for my child. Now the question is, should I make the payment? When I make the payment by check, should I specify my DIN behind the check? Yes or no? Ideally, no. Why? Because the iPhone was for my child. It is a personal expenditure. Okay, but if I think I should give iPhone to every employee of my company, in that case, when I make the payment by check, am I required to furnish my DIN or not? Yes or no? That is a yes. That is a yes. A director must furnish his DIN language wherever he signs in the capacity of a director. When I bought something for my son, daughter, I was not acting in the capacity of a director. Is this concept clear? Okay, practically you don't put your DIN behind every check. When you open your account with the bank, at the bank account form, you give your DIN to the bank so that they verify every time. That was an example for you. Okay, and then comes the penalty for contravention under section 159. 159 says penalty for contravention. Contravention of what? Contravention of what? Exactly, contravention of what? What kind of contravention? What is the nature of contravention? Careful here. Sabse first, the first point we used was, as per 152, you must have a DIN if you want to become a director. Okay. Then how to get a DIN? Apply in 53, you will be allotted in 54, but 55 says don't accept more than one DIN. 56, what will you do of the DIN? Give it to the company. 57, what will the company do? Forward it to the ROC. 58, sign wherever you sign in the capacity of a director, furnish your DIN. And 59 for penalty. Now let us analyze penalty for what. As per 52, I must have a DIN if I am acting as a director. I am acting as a director without obtaining a DIN. Isn't it a contravention? Yes. Okay. So if I do not comply with 152, I should be liable to a penalty. 53, I did not apply for the DIN, so I should be liable to penalty. Oh, have you applied for the DIN till date? No. Are you liable to any penalty? No. So am I not liable to any penalty. Means it is up to me whether I want to apply or not. Allotment 53, 54 allotment. CG did not allot to you. What will I do? If CG does not allot, what will I do? But if I obtain more than one DIN, 55. If I fail to intimate to the ROC, if I fail to intimate to the company, 56. Meaning for contravention under section 52, 152, 155 and 156, 152, 155 and 156, I will be liable to a penalty under section 159. I will be liable to a penalty under section 159. What is the penalty that I will be liable to? Carefully, the penalty that I will be liable to will be as follows. Look at the chart on your screen. Are we clear? What we have done is nothing but section 153 to 159 along with a tinge of 152. 152, I'll take a quick recap, a super quick recap. 152, you must have a DIN if you want to become a director. How? 153, apply. 154, you will be allotted. 155, don't accept more than one. And 156, what will you do? Give it to the company. Give it to the intimate to the company. 157, company to intimate to ROC. 158, furnish, where you sign in the capacity of director. And 159 talks about penalty for contravention of 152, 5 and 6. Are we clear? Okay. We go to the next concept. The next concept talks about, let us begin with the base. Let us begin with the base, that is your section 149, the starting point of your directors chapter. 149 talks about a company to have board of directors. Means if you are a company, you should have some management, because the shareholders cannot run the company. So if you are a company, you need to have some management, and if you are a company, to have some management, you need some board of directors, right? So what kind of a company and what kind of board of directors, how many board of directors are required? That is all you need to do in section 149. Okay, section 149, the first point of section 149 says, how many board of directors? What is the minimum number of board of directors required? Carefully, the minimum number of directors required depends on the type of company. The type of company, whether it is a public company, private company, or a one-person company. Public, private, or a one-person company. Public company, minimum 3. Private company, minimum 2. And one-person company, naturally, minimum 1. Public company, minimum 3. Private company, minimum 2. One-person company, minimum 1. It means, what is, dhyan se, what is, carefully, what is the minimum number of directors you require? 3, 2, 1. Minimum 3, 2, 1. Maximum 15. 1, 5. 15. As in 15 means, carefully, 15 means whether you are a public, private, or OPC does not matter to me. You can have maximum of 15 directors. I say this provision is absolute nonsense. Why? Because it is my company. It is my company. I know my company better than any law in force. And so, if being my company, if I require more than 15 directors, how can you prohibit me from appointing more than 15 directors? I require some additional people also to act as directors of my company. We have a strength so much. So law says fine. If you have a strength so much and you require more than 15 directors, carefully, you will have to pass a special resolution for appointment of every additional director at your general meeting. You will have to pass in a special resolution, and then you can appoint any person as a director that you require from your general meeting. Clear? Absolutely. Okay. The concept was minimum how many directors? Public, private, OPC, 3, 2, 1. Maximum 15. Subject to additional directors if required, then pass a special resolution. Okay, now the thing is, the new thing here is the one-person company, where you said minimum 1 director, and then we said maximum 15 directors. Moral of the story, one-person company does not mean it will have only one person as the director. It should have at least one person as the director. What is the whole concept of one-person company? From where did it come? Is what you need to know. See, practically talking about only your syllabus, minimum directors 3 to 1, maximum directors 15, that's it. But there is no logic given in your study material as to why one person company was evolved, the new concept, because in 1956 Act, we never had anything as a one person company. It came with 2013. What was such that it had to come? Why did it enter? And minimum 1 means you can have more than one also in one person company. How is that possible? Carefully, again, one person company was evolved as follows. There was a big fight between the partnership firms and the government. The partnership firms had a fight saying, boss, we are such huge partnership firms, we are even bigger than some companies. So we want the benefit of limited liability. We want, because the liability of partnership firms is unlimited, joint and several. We want the benefit of limited liability, and so what we are aiming at is, carefully, what we are aiming at is a limited liability partnership requirement from the law. Law said, okay, considering the fact that yes, you are bigger than certain companies, you are huge, and the liability, the quantum of liability if attracted will also be huge, we give you the benefit of limited liability. There came the sole proprietors. The sole proprietors came, even we want limited liability. You made a limited liability partnership act for partnership firms, make an act for us. Central government says, do you think we don't have any better thing to do in life? Seriously? Is it only the Companies Act that we have to look after? There are no other acts, right? So let's do one thing. Let's do one thing. What we can do is, we can give you the benefit of a one-person company by giving you a place in the Companies Act itself. Then came the amendment of the one-person company entering the Companies Act 2013, where if you are acting as a one-person company, if you are registered as a one-person company, you will enjoy the benefit of limited liability, but you will have to do certain legal compliances in addition to a sole proprietor. That is natural, right? So being a one-person company, I got the benefit of limited liability. The question is, how can we say a one-person company? In case of a one-person company, minimum one is okay, but you can have more than one also. I'll give you an example, guys. For example, I am a person who's got a lot of money. I am a person who's got a lot of money, and so I want to invest it in certain business. I'm a person who has a money, want to invest it in certain business. I don't know what business should I invest in. So I inquired into the market and I came to know there is a business of imitation jewelry. There is a business of imitation jewelry where you can have 200% profit margin. You can have 200% profit margin. I was like, this is beautiful, guys. I'll do this business. So I made a setup. I bought the machinery. Ekdam proper, and then came the day where I was supposed to start a business, and I was standing like this. How to run this machine? What is the input? From where does it go? How does it come out? Whatever comes out, is it finished or semi-finished? Is there any concept of normal loss or some abnormal loss? I mean, I don't know how to do this business. Just because I had an idea in my mind and the money to invest, I started the business. But I don't know how to run this business. Getting my point? So I went to a person who already owns a factory of imitation jewelry. I considered one of the senior workers working there. I had a word with him. I told him, dude, bro, do you mind working with me? He was like, why should I work with you? I'm already working here. I told him, I am offering you the position of director. What you are earning here is your salary. What you will earn with me will be the managerial remuneration. That is a part of the profit that you earn for me. Do you mind working for me? He was like, okay. I don't mind working for you as the director of your company. He is the second director of my company. Guys, I had the money, he had the brains. We started the business of a one-person company together. Are we clear? The business is registered in my name. He is working as an additional director that I have appointed. That is how one-person company can have more than one director also. Clear? Absolutely. Okay. So then we come to the next concept. About the next concept, minimum 3 to 1, maximum 15. Then came a concept of women directors. Women directors, does every company require women directors? Yes or no? If yes, then how many? If no, then why is this provision here? Carefully. As per Companies Act 1956, there was no concept of the woman director. But as per Companies Act 2013, there is a concept of woman director which encourages you to woman empowerment, which encourages you to appoint women as the directors of your company. So does every company require a woman director? The answer is no. Then woman director we divided in 3 parts: a listed company, an unlisted company, and a private company. Listed company, unlisted company, and a private company. A listed company, always at least one woman director is required. Unlisted company, if you open the act and see unlisted company, you will find a star which will give you the reference to the bottom of the page, and from there you will get the reference to the rules of that particular chapter, which means the act does not include all the conditions. The conditions are given in the rules book. You need not open the rules book. I am giving you the condition. Meaning, for unlisted public company, it has to appoint a woman director if the prescribed conditions are satisfied. Now, what are the prescribed conditions? Very carefully, the prescribed conditions are paid up share capital or turnover or outstanding loans. Normally, that is the prescribed conditions everywhere. For woman director, the prescribed conditions are paid up share capital and turnover. The paid up share capital greater than equal to 100 crores or turnover greater than equal to 300 crores, you will be required to appoint at least one woman director. If you want to appoint more than one, you appoint if you can afford. You appoint if you can afford. Otherwise, 100 and 300 is a big amount. Just to remember, more than 100 crores paid up share capital, more than 300 crores turnover, at least one woman director. Now, for the private company, it is not applicable. Not applicable means, if I am a private company and I want to appoint a woman director. Dude, it is not compulsory. My dear friend, it is not compulsory. If you want to appoint, you can appoint. Correct? For a listed company, you have to appoint. Unlisted company, the conditions I told you, and for private, not applicable. Then we go to a next concept about, okay, for this was for the woman director, then what is it about the independent director? For the independent director, carefully, independent director is a concept that has arisen very important way, in a very important way with Companies Act 2013. Companies Act 2013 has raised the bar of importance for two people. One is the independent director, another is a company secretary. One is the independent director and another one is a company secretary, where the company secretary has been dedicated to whole sections, section 204 and 205 of Companies Act 2013. About the independent director, how is his importance increased? I will explain to you right away. For example, does every company require independent director? Mind you, not every company. Then let's divide it in three parts. First, listed, unlisted, private. Same, listed, always required. How many? How many? For women it was at least one. For independent directors it is at least 1/3 of the total directors. At least 1/3 of the total directors should be independent directors. For unlisted, subject to conditions as may be prescribed. What are the conditions? As I told you, paid up share capital, turnover, outstanding loans, paid up share capital, turnover, outstanding loans, paid up share capital greater than equal to 10 crores. Turnover greater than equal to 100 crores and outstanding loans greater than equal to 50 crores. But mind you, there is one thing you need to remember here. It is outstanding loans greater than 50 crores. There is no equal to. Now comes the question, sir, this is exactly where we face problems in the exam. While writing the paper, we only have a fraction of second to think whether should I put the greater than equal to or greater than. Sir, we do not understand this concept. It is difficult to remember. Guys, if you don't understand the logic, go by the magic. If you don't understand the logic, go by the magic. I am giving you a magic. For example, paid up share capital, wherever you see in the Companies Act 2013, for your syllabus, wherever you see in the Companies Act 2013, for paid up share capital, put greater than equal to always. For turnover, put greater than equal to always. For outstanding loans, put greater than always. Subject to a couple places where it will be greater than equal to. One is in your company audit and one is in the later section. I will explain, while explaining I will give it to you. But for now, you only have to remember paid up share capital greater than equal to turnover, greater than equal to outstanding, greater than. Absolutely clear, right? Okay, so either of the three conditions are satisfied, then I will have to appoint minimum 2 independent directors, and for a private company, leave it, not applicable. Correct? So what we have done up till now, minimum directors 3 to 1, maximum directors 15, additional subject to special resolution. Then we did women directors, listed, unlisted and private. Then we did independent directors for listed, unlisted and private. Then we do another concept of resident director. The Companies Act 2013 says every company must have at least one resident director, that is a person who has stayed for more than 182 days in the previous year. Correct? So at least one resident director, because we believe it is easier to trace such a person if the company commits any fraud or runs away. Right? So at least one resident director should be there. Now we come to another concept. I told you the bar of importance for the independent director has been raised significantly. How? Listen to this. The bar of importance has been raised as follows. Independent director, who can become an independent director? There is a separate subsection provided, section 149 subsection 6. Who can become an independent director? Very carefully, who can become an independent director? We will do it with the help of a key. There are many points, so to remember, we'll use a key. The key is I am Rustam with R capital, everything small, of when, VEN. Everything in what I said will be capital except for Rustam, USTOM, will be small. I am Rustam of when. I stands for integrity. Any person who wants to become an independent director shall be a person of integrity. Nothing difficult here. The only thing you need to remember is any person who wants to become an independent director shall be a person of integrity as may be determined by the board of directors, right? But if you are a government company, I am talking about a very new amendment. Careful. If you are a government company, then the words board of directors shall be substituted with the words particular department of the central government or state government, right? So any person who wants to become a director shall be a person of integrity as may be determined by the board of directors normally. But if it is a government company, then a person of integrity as may be determined by the particular department of the central or state government or both. Correct? That is for I. Then we go to M. M stands for, okay, we've got two M's. We've got two M's. Both the M's stand for monetary. M1 monetary, M2 monetary. Then sir, why the hell in this world are you putting two M's if both are monetary? I'll explain you with logic. Come here. M1 talks about monetary transactions done with the company by me, I, me and myself. Right? M2 talks about monetary transactions done with the company by my relatives. Okay? Monetary transactions, here it's by me, here it's by my relatives. Coming to the relatives later on. By me, first thing, I am not allowed to do any monetary transaction with the company. This will be a problem. If the provision says I am not allowed to do any monetary transaction with the company, this will be a problem. What problem? The problem is I am going to be appointed as an independent director of Reliance Industries Limited. I am going to be appointed as an independent director in Reliance Company. In the Reliance Company, we will make it simple. In the Reliance Company. Okay. But the electricity that I receive at my place is of Reliance. Meaning, at the end of every month, I conduct a monetary transaction with Reliance. And the provision says any person who wants to become an independent director shall not enter into any monetary or pecuniary relationship with the company. Monetary, pecuniary, the words are different, guys. The feeling is same, right? So, this is a problem. If I receive an electricity of Reliance, I cannot become an independent director in Reliance. So like this too, guys, nobody can become, because most of the people receive electricity from Reliance. Isn't it a practical problem? Yes, naturally it is a practical problem. That is why for this provision you have an exception. The exception is if you have a monetary transaction with that company, if you conduct a monetary transaction with that company and such transaction is conducted, carefully, such transaction is conducted in ordinary course of business or at arm's length price, in ordinary course of business or at arm's length price, then it is allowed. What do you mean by ordinary course of business and arm's length price? Very carefully, ordinary course of business and arm's length price means Reliance manufactures or generates electricity. Does it do it only for me or does it do it for everyone? Everyone. So it supplies electricity. Does it distribute electricity? When it supplies or transmits electricity, does it give it only to me or to everyone? If it gives it to everyone, if it generates for everyone, now in that particular case, carefully, in that particular case, I receive the bill. The bill that I receive, do I receive the bill saying minus 10% discount for you? No. But I receive it in an ordinary way. I receive it in an ordinary way means if I do not pay the bill, I will also be liable to the consequences. Correct? So there, this particular point is considered as transaction that is entered in the ordinary course of business and at an arm's length price, and hence such a monetary transaction is allowed. तो अब अपन आते हैं M2 पे. Next we proceed to M2. M2 talks about again monetary transactions. What is this monetary transactions? As I told you, these monetary transactions, carefully, these monetary transactions are my relatives doing with the company. Okay, means if my relatives do any transactions with the company, then I am again ineligible to be appointed as the independent director. Okay, then let us take another example. For example, I was supposed to be appointed as an independent director with Reliance. So we were sitting in the board meeting, we were sitting in the boardroom, and if you have seen probably in the movies, then the boardroom has a big round table, so many chairs around, and in front of every chair there is one notepad, a pen, a small Bisleri bottle. It was the same setup, and it so happened that around 5-6 chairs were empty, as in they did not have the Bisleri bottle or stationery thing. Mr. Mukesh Ambani entered and he just had a look and he called the peon. What is this? Where is the stationery? Where are the notepads? Where are the pens? The guy, poor peon, said, sir, stationery is over. So Mukesh bhai said, dude, go down. There's a shop. Get some and place them. Said okay. He went down, ran down and bought the stationery, placed the stationery, the pen, the notebook, etc. and then started the board meeting wherein I was sitting, and fortunately and unfortunately, I don't know, but I had that notepad in front of me. I just opened it and I was like, I have seen this kind of a notepad somewhere. I have seen this kind of a notepad somewhere. I asked Mukesh bhai, sir, where did you get this notepad from? He was anxious to know why am I being appointed as an independent director, bloody asking about the notepad. Being anxious, he told me, we bought this from the shop downstairs. Why? I was like, oh, Mr. Mukesh, what have you done? It was like, what happened? That shop belongs to my brother. So, you made a monetary transaction with my brother. Monetary transaction with my relative. I am ineligible to be appointed as independent director now. Is this valid or invalid? Is such a provision valid under law or invalid under law? Carefully, what do you think should it be? Should I be ineligible just because Mr. Mukesh happened to make a transaction with my brother? What transaction? Purchase of a few notepads. Are you getting it? Meaning, the point remains that, okay, here the transaction should not be termed as invalid because the transaction was conducted in the ordinary course of business and at the arm's length price. That is the first thing. Second thing, there is a limit specified in the law. There is a limit specified in the law that up to this particular limit, if the company happens to transact with the relative, then it is allowed. If the company transacts with the relative beyond this particular limit, then the person shall be disqualified. But even if the company transacts beyond that particular limit with any person, but that transaction is in ordinary course of business or at arm's length price, the person shall not be disqualified. Are we clear here? Okay. Coming to the limits, what are the limits, guys? Very carefully, the limit is 2% of the gross turnover, or you can say total revenue, or rupees 50 lakhs, whichever is less. This is your limit. If you transact beyond this limit, not in ordinary course of business or arm's length price, then your relative shall not be eligible to become an independent director. Now the doubt will come, sir, at least explain the meaning of relative. What do you mean by relative as per the Companies Act 2013? So the doubt will be, sir, definition. What is the definition of relative? Carefully, the definition of relative as per Companies Act 2013. I will say it only once, I won't repeat. Listen to me very carefully. The definition is, for me, my relatives will be 2 up, 2 down, 1 left, 1 right, 1 center. Once more, 2 up, 2 down, 1 left, 1 right, 1 center. What does this mean? Sir, what does this mean? For me, my relatives are 2 up, my mother and father, 2 down, my son and daughter, 1 left, my brother, 1 right, my sister, and 1 center. My spouse is also coincidentally a relative as per the Companies Act 2013. Right? So all you need to remember here is, when I said 2 down, we said son and daughter, it includes their spouses also. Okay, and it also includes the legally adopted son daughters. Clear? Okay, so those are your relatives. So that is your monetary transactions with relatives. I am Rustam. We are concerned with the R of Rustam. R stands for related. Means I should not be related to the company, or my relative should not be related to the company in any matter. What do you mean by related? Simple. Related means I should not have been the promoter or director or key managerial person of that company ever before I am willing to become an independent director in that company. Are we clear? That is your related. I am Rustam of O. O stands for O, the favorite of every student. Others. Others as in others as may be prescribed. Okay, now talking about others, there is an amendment here. The amendment is, earlier for the others point, there were around 8 points into others. So we used to write it as others. But now others is specified with only 3 points, rest everything has been eliminated, right? So talking about the 3 points that you need to remember in others are, first, for appointment of, carefully, appointment removal of key managerial person, appointment or removal of key managerial person. So O stands for the favorite of every student, that is others as may be specified. Any other conditions as may be specified from time to time, or for any law for the time being in force by central government, those will be applicable. That means any person, you can say, who is having special skills with respect to management or economics or law, or as required by the company, basically. Correct? Okay. OF. F stands for firm. We divide firm in 2 parts. We have 2 type of firms. One is your legal consultancy firm and one is your audit firm. Carefully, one is your legal consultancy firm and one is your audit firm. Listen to me very carefully. On the chart that is in front of you, I am reading out what is written there. For audit firm, it should not have been the proprietor, partner or employee of such firm in any of the 3 preceding financial years preceding the current financial year in which you are going to be appointed. Okay, now for the legal consultancy firm, first thing, this point as it is, copy paste. You should not have been a proprietor, partner or employee of such legal consultancy firm for a period of 3 years preceding the year in which you are going to be appointed. Plus, there is one more condition there. If you can see, there is one more condition which says the transaction value with the company should not be equal to 10% or more of the gross turnover of that firm. Now, carefully, come to me. If the company has done a transaction with a firm and the gross turnover of that firm is 100 rupees and the transaction value is 11 rupees, meaning the firm is earning more than 10% of its total revenue from the company, this company itself. In that case, the particular year in which the transaction value exceeds 10%, I shall be ineligible to be appointed as an independent director in that firm. Are we clear? Absolutely. Okay. Talking about of, then we go to when. When stands for V. V stands for voting powers. What do you mean by voting powers? You or your relatives should not have any voting powers in the company. You or your relatives should not have any voting power in the company. Should not have any voting power in the company. What do you mean by voting power? How much voting power? 0% voting power. I have 1 share out of the 1 crore shares that they have sold. What do you think I can influence the company with? Clear? So there is a condition. You including your relatives, carefully, you including your relatives should not hold more than 2% of the total voting power in that company. You including your relatives should not hold more than 2% of the total voting power in that company. If you do, you are not eligible to be appointed as the independent director of that company. Clear? Okay. Now mind you, wherever I am saying company up till now, I have been meaning company includes its holding, its subsidiary and associates. Its holding, subsidiary, associates are included in the company. They are considered as the relatives of the company. But in case of voting power, company includes company itself. Right? Okay. Coming to the next point. VEN. E stands for, carefully, E stands for employee. Employee as in, I should not have been the employee of that particular company. I should not have been the employee of that particular company in the immediately preceding 3 years where I am seeking the independent directorship in that company. From the date where I am seeking being an independent director in that company, I should not be an employee of that company for the preceding 3 years. And last is your NPO, that is a non-profit organization. In case of a non-profit organization, carefully, any non-profit organization, what is the income for non-profit organization? It is subscriptions, donations, etc. So any non-profit organization that is earning its revenue, subscriptions, donations, etc. more than 25% from a particular company, then the CEO or the chairperson of this NPO is not eligible to become an independent director in that company. Clear? Are we clear? What we did is, who can become an independent director? I am Rustam of when. Now, once appointed, if eligible, once appointed, you think he will be appointed for lifetime? No, he will be appointed for a specific term. The specific term is a period of 5 years. The specific term for which an independent director can be appointed is for a period of maximum 5 years. But okay, 5 years are over, then is he eligible for reappointment? The answer is yes. He is eligible for reappointment. He is eligible for reappointment. He can be reappointed for another term of maximum 5 years. Oh wow, means after that he will be eligible for reappointment for another term of maximum 5 years. Don't even think about it. Don't even think about it. Carefully, the provision says an independent director can be appointed for a term of 5 years, maximum 5 years. He can be reappointed for another maximum term of 5 years, after which he cannot be reappointed. A cooling period shall be attracted of 3 years. Are we clear? Okay, maximum 5 years plus maximum 5 years plus 3 years. Can I appoint him for 8 years? Can you appoint him for 8 years? Don't even think about it, guys. What we said, he can be appointed for one term of maximum 5 years, then reappointed for another term of maximum 5 years, because when you appoint him for the first term of maximum 5 years, you are required to pass an ordinary resolution, and when you reappoint him, you are required to pass a special resolution. Are we clear? Okay. So in that case, what is the amount that we will be paying to him? What will be his remuneration? Talking about the remuneration to the independent director, very clearly, remuneration to the independent director, he will be eligible to profit-based commission, profit-based remuneration. He will be eligible to expense reimbursements, profit-based commission, expense reimbursement. He will also be eligible to sitting fees separately, but he will not be eligible to ESOP. ESOP, employee stock option plans. Why not eligible to ESOP? Logically, ESOP means employee stock option plans. It is something you offer to the employees of your company, and he is an independent director, as you said, of the company. If he is an independent director of your company, how do you think you can offer him something that you are offering to your employees? Are we clear here? Absolutely. Okay. Then we go to the next section. The next section talks about section 167. 167 talks about vacation of office. It is 167 talks about vacation of office, as in here you have to remember certain things like what are the reasons where a person is required to vacate his office. What are the reasons where a person is required to vacate his office? Carefully. I'll tell you a story. Let's listen to a story. I had a friend. Okay. Meet my friend, my eligible friend, my very important friend, close friend. This particular friend of mine, carefully, was also a director in my company. He was a director in my company. My company is located at a place known as Ahmedabad. My company is located at a place known as Ahmedabad. He was a director in my company, and something happened. Something happened and section 164 got attracted. 164 talks about disqualification of directors. He got disqualified from my company. Something happened, 164 was attracted, he became disqualified from my company. He had to vacate his office. Okay. My company was in Ahmedabad, where he was a director with me, and 164 was attracted. He had to vacate my office. Now, being 164 being attracted, where he had to vacate my office, he was under depression, under super depression. Now we have to do something. How to get over this depression? He thought, okay, let me make a trip to Bangkok. Let me make a trip to Bangkok. Bangkok will help me to get over the depression in a very good way. Okay. He made a trip to Bangkok, but it took him nearly more than 12 months to get over depression. What kind of a person he is? It took him nearly more than 12 months at Bangkok to get over the depression, and meanwhile he forgot that he was not only a director in my company, he was also a director in many other companies, right? So other companies where he was a director, one of them started getting some doubts. Why is this person absconding? Where is this person running? Let us inquire all the transactions, all the decisions that he has taken in my company. They started the inquiry and they came to know he had entered into a transaction on behalf of the company with a person in Chennai. And he was found to have some interest in that person. With a person in Chennai, he had entered into some transaction and he was found to have some interest in that person. Okay. He was found to have some interest in that person. So now the company wants to find out what is the nature of interest and whether that interest has any kind of influence on his decision. So the people have started to search him. It has been 12 months, nobody has seen him because he is in Bangkok. We found this person in Chennai with whom he has some interest. Finally, we found him in Delhi. Finally, after we found him in Delhi, we took him to a pub. Had him sit there, some good rock music being played in the background, good dancers there, food, drinks, everything, where he's enjoying himself. And then we asked him, dude, did you happen to do any transaction with any of the interested parties in Chennai? Did you happen to do any transaction with your interested parties in Chennai? Mind you, I am asking this to him in a pub at Delhi. Did you happen to do any transaction with your interested parties in Chennai? He is blunt enough to say no. Not once, not twice, not thrice. I asked him 184 times. How much? 184 times to be precise. Boss, dude, please tell me, have you entered into any transaction? Have you entered into any transaction with any interested party in Chennai? He says no. 184 times a guy says no, I haven't. And then the pub goes silent. The pub goes silent and there comes an announcement. There comes an announcement in the pub from the European court saying, Mr. X, you have been disqualified to act as the director from every company in Europe. Okay. there was an announcement by the court. There was an announcement by the court which said you have been disqualified to be acting as a director. You have been disqualified to be acting as a director from every company. Now, Mr. X is now again frustrated. Back to his depression, doesn't know what to do, and responsiveness to stimuli, he slaps some person sitting beside him. He happens to slap some person sitting beside him, and had it been an Indian, wouldn't be a problem. He would have kicked. But it wasn't an Indian. It was a person from France. Being a person from France, what he did was, he filed a complaint against Mr. X. He filed a complaint against Mr. X, and Mr. X was termed for imprisonment for around 8 to 10 other months. Mr. X was again termed to imprisonment for 8 to 10 other months, means the government of India is now very much pissed with Mr. X. Doesn't know what is this person up to. Just because he was disqualified from one company at Ahmedabad, he happened to go to Bangkok for a period of 12 months, more than 12 months. And then when we were confronting him about a transaction with an interested party at Chennai, he is not disclosing it. We confronted him, you know how many times? 184 times at that pub in Delhi. But he is not disclosing any fact. On the top of it, he happens to get an announcement, he happens to know something new, that he has been disqualified as per the European court from becoming a director in any company, and therefore he, out of frustration, slaps a person who is not even an Indian. Happens to spend more than 6 months, around 8, 10, 12 months in a imprisonment in France. Something is wrong with this person. So what happens is, the Supreme Court happens to call him. You know where is the Supreme Court of India? You must be knowing where is the Supreme Court of India. Do you think it is in New Delhi, right? Noida or Delhi probably, right? Don't even think about it. Our Supreme Court is located at Goa. You must have heard about a beach known as the Kalangut beach. Right in the center of the Kalangut beach lies our Supreme Court. This is fictitious, just an imagination. I just need you to imagine like this, just the way I am telling you to remember the concept. The Supreme Court lies in the center of the Kalangut beach. And there, where he was taken at the Supreme Court, the verdict was out saying, dude, Mr. X, you have been removed from pursuing any of the provisions of the Companies Act 2013. You have been removed from the pursuance of any of the provisions of Companies Act 2013, means the Companies Act 2013 does not apply to you. You are ineligible to do anything as per Companies Act 2013. He was, I don't know what to do, what is happening to me, because the impact of the Supreme Court decision in Goa was that he was disqualified from the subsidiaries in Hong Kong and Singapore, from other companies in Hong Kong and Singapore also. Now, very carefully, where he was removed from the companies in Hong Kong and Singapore also, what you need to do, very carefully listen to me now. A quick recap. What happened first? He was disqualified from my company at Ahmedabad. Next, he went to Bangkok to get over the depression. Wherein we found out some transaction with interested party at Chennai, for which we confronted him 184 times at the pub in Delhi, where the pub went silent and there was an announcement from the European court to disqualify him. Responsiveness to stimuli, out of frustration, he happened to slap some person who was a French guy, took him to imprisonment in France for a period of 8, 10, 12 months, I don't know. And then the government is pissed with him, so called him to Goa at the court and told him, we are withdrawing you from the pursuance of the provisions of Companies Act 2013, which had an impact. He was removed from being the director in a company in Hong Kong as well as Singapore. Right? What we have done is, very carefully, what we have done is, we have remembered section 167, subsection 1, 167, vacation of office. Subsection 1, what are the circumstances where a person will have to vacate his office? What are the circumstances? We have remembered the circumstances with the subsection clause number very carefully. How? Section 167 talks about vacation of office. Subsection 1, first part, what are the reasons? There are 8 reasons to be precise, and you have remembered, my friend, all the 8 reasons with the subsection numbers. The 8 reasons are A, B, C, D. The 8 subsections are A, B, C, D, E, F, G and H. Right? Now, A, B, C, D, E, F, G, H are the 8 subsections. Remember, first subsection says, what are the reasons where you are required to vacate your office? First subsection A for Ahmedabad, disqualification under section 164. B for Bangkok, where you absent yourself from attending any board meeting for a period of 12 months or more. You was in Bangkok for more than 12 months. C for Chennai, you enter into a transaction with any interested parties. D for Delhi, you fail to disclose, you do not disclose the transaction that you have entered with the interested party in Chennai. You fail to disclose. Non-disclosure of transactions entered into with interested parties, that is, hey, how many times did you ask him? How many times? 184. That is your section 184 that talks about disclosure of interest with the related parties. Then comes Europe, the European court announcement, where the court disqualifies you specifically from following the provisions of this act. Then comes France, where we said he was imprisonment for a period of 6 months or more. 5, because he slapped a person. That is an offence involving moral turpitude and imprisonment for greater than equal to 6 months. Then was G for Goa, Goa Supreme Court, where you have been withdrawn from pursuing any of the provisions of Companies Act 2013, resulting in you not being a director in the company in Hong Kong and Singapore. Hong Kong and Singapore, mind you, it is the holding and subsidiary. The H is for holding and subsidiary. Are we clear with 167 subsection 1 clause A, B, C, D, E, F, G, H? Any of these clauses become attracted. Any of these clauses are attracted, be it Ahmedabad, Bangkok, Chennai, Delhi, Europe, France, Goa or Hong Kong, Singapore. Any of these clauses are attracted, this person will be required to immediately vacate his office. Are we clear? Next concept, if he does not vacate his office, then he will be liable to a penalty for contravention, which shall be imprisonment up to 1 year or fine minimum 1 lakh, maximum 5 lakhs or both. Okay. Then something happened in my company where all the directors of my company were attracted to some to A, some to B, some to C, some to D. Somehow all the directors of my company were required to vacate the office. What next? Can it happen? Yes, it can happen. Some of the provisions of section 167 were attracted to different directors of my company, and everyone was required to vacate the office. Who do you think will run the company? The shareholders? Don't even think about it. The shareholders need not be CS, CS or MBA like us, like you. The shareholders may be a milkman, maybe a cobbler, right? They have the right to purchase shares, but they don't know how to run the company. So how do you think the company will run if all the directors are required to vacate the office? That is where the Father of Companies Act will come into the picture, the central government will come into the picture, and it will appoint the requisite number of directors in such a company whose term will be till the shareholders come, that is till the meeting of the shareholders. Right? The central government will appoint the requisite number of directors that the company requires, and then if you talk about the private companies, the private companies may impose some additional conditions for vacation of office. Additional as in more than A, B, C, D, E, F, G, H. More than H, more than the 8 conditions that we have done, the private companies may impose certain additional conditions because what they aim is quality first than anything else. Right? So that was your section 167. Thank you.